Court does call the case. Peninsula Place versus, is it Trellis Lane?
Good afternoon, Your Honor. David here on behalf of the plaintiff.
Sir, your name?
Sorry, Judge. Trellis Lane.
All right, this is the date for non-jury trial, and this is a non-payment of rent case. How much is the plaintiff claim is owing?
Your Honor, the total balance at this time is $3,320.17 plus court costs of $161. $3,320.17.
All right.
Your Honor,
Sir, of that amount, is there any that you believe that you owe?
no.
You were going to say something.
I was going to ask to Jack what he was about to say as far as about the numbers. About saying what I owe, but you already answered the question. Ask me the question.
And Mr.
Break down that amount if you want me to, Your Honor.
Pardon?
I can break down the amount if you'd like me to.
Just one moment. We'll get to that. Sir, can I ask you, I received the documents from you. Is there a reason why you don't think you owe that amount?
Because it's already been paid, Your Honor. Far as reporting adverse information about a co-signer Act 211 of 1989, Peninsula Place is trying to held me liable as the co-signer when I have an interest and a signature and I'm a natural person. So they're trying to hold liable.
Okay, so let me ask you this.
Okay.
Just so that I have the background on it. You reside in this unit that's at, I think 315B.
Correct.
At 1000. You reside there.
That's my place of abode.
Well, you live there, right?
Depends what you're talking about. I'm acting as a consumer. So, as far as like my, I'm there on special appearance, and my estate stays there. But as far as a natural man, I don't have no place.
You can always tell when a sovereign citizen walks into court because they truly believe paying for anything is optional, and somehow the world owes them unlimited freebies, and they try to dress it up with fancy phrases. But at the end of the day, it is the same tired routine. And every time you ask them why they refuse to pay, they act shocked, like the rules were never meant for them. And the moment you press them for an answer, they fall apart because deep down they know the truth. And the truth is simple. They just don't want to be responsible for anything. And that mindset always catches up to them eventually, because reality does not bend to fantasy, and the court certainly doesn't either. And watching them try to argue around basic responsibility is like watching someone pretend gravity doesn't exist and still expecting to float.
As far as my estate and my...
Okay, so when whoever is in this courtroom leaves here to go to what they would call home, where does this person that's sitting here go?
To my place of abode, Your Honor.
Which is where?
A Peninsula Place.
Okay. At the 315B.
Correct.
All right. That's what I need to know. Okay. Do you have a ledger?
And I'll give Mr. Lane a copy also.
Thank you.
And Mr. Fantera, this would be your witness, is that correct? Okay, why don't we do this? Why don't we have her and Mr. Lane sworn in, please?
Thank you.
Yeah, one minute.
Right. Swear affirm the testimony you're about to give.
I do.
Raise your right hand. Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, could I give you a real quick context on that?
Yes, please.
We had a previous case last summer where Mr. Lane received Sarah funds. And when we had I have a copy, I have a case number, I have a copy of the unsigned copy of the COD. That was entered on September 9th. SOS paid his rent through September, and it left a small balance of, I think about $119, which we waived. So the balance, even though it doesn't show it on there because we didn't actually get the SOS check till sometime later, his rent at the end of September was zero.
Got it.
So the total balance that's on there is 5 months of rent at $513, water and sewer bills, electric bills. There's not even any late fees, and then there's 161 in court costs. So I just wanted to clarify that, in fact, none of this goes back past September 30th. In fact, I don't know if you remember, we actually, when we had the previous case, Mr. Lane had sued Peninsula Place seeking the return of all money he paid forever. And he denied that he owed money, but simultaneously applied for Sarah, and he denied he applied for Sarah. You verified with probably Aaron at the time that he had applied for Sarah. He ended up getting Sarah funds. He would not sign the COD, and then you basically gave him a choice. I'll enter the COD, or we'll have a trial and I'll give you a judgment. But it sounds like he's raising some of the same stuff now that he attempted to raise.
Your Honor, free to speak?
Go ahead, sir.
So, Your Honor, when I applied for, so first I didn't know what I was applying for. So when I applied for Sarah funding, I ended up giving my principal information, which was my name, my date of birth, and my social security number. Basically, I'm here today saying that I gave my principal to Peninsula Place and I've never received any consideration.
Your Honor, I don't understand what that means.
The funny thing is this defendant thinks he is outsmarting the entire system. But the irony is that the very documents he relies on are the ones dragging him deeper into trouble. And what's even wilder is that the same sovereign citizen group that's been guiding him hasn't been paying their own bills either. So they are all headed in the same direction fast, and the judge sees right through every excuse tossed into the air, and the courtroom energy shifts the moment the facts come out, because reality always wins that battle, and all their grand speeches collapse when you bring up something simple like rent and contracts, and suddenly the bravado disappears completely, and now he is standing there trying to pretend he's shocked and innocent. And everyone watching knows exactly how the story ends. And none of it ends with free housing or made-up paperwork saving the day.
However, are you Trellis Lane? That's a yes or no. Because I'll tell you, if you are, then we'll go ahead with the trial. If you're not Trellis Lane, then I'm going to give them a judgment by default because Trellis Lane hasn't shown.
I'm here on special appearance.
No, you can't do that. You are not an attorney at law because you can't appear for somebody else. So my question is, and I'll ask it again, are you Trellis Lane?
Yes, Your Honor.
Thank you. So, Mr. Lane, October of 2022, did you pay rent to the landlord?
Yes, Your Honor.
Okay, and how did you pay that?
I'm paying with my credits that's on file. So I sent instructions back in May, basically to get my account zero every month.
You do what?
I sent instructions back in May, then I sent another one to December to the CEO.
The CEO of what?
American Campus Communities. Saying it right. So he's seen my email, so he's aware of what's going on. Basically, like I say, I'm looking for consideration. I have not been getting no consideration, no adequate consideration.
Well, you get adequate consideration for the contract and any payment by virtue of the fact that you have a residence. So I don't think consideration is even an issue.
But Your Honor, I have several questions.
Well, you can go ahead and ask your questions, but I don't know. Let me just ask this. October 2022, how did you pay your rent?
I paid with my took the bill, I endorsed it.
Did you give them cash?
We don't have,
We being whom?
I'm saying, it's a credit system, Your Honor.
So what?
Credit system. We don't.
So who's in charge of this credit system?
You said who's in charge?
Surely.
I mean, we haven't had money since 1933, the American Bacon Act.
We being whom? Who are you talking about when you say we haven't had money? Who is we?
As far as like the United States haven't had money since 19.
Oh, they definitely have, and I spent my share. So I don't know. You're saying you gave them credit.
Yes.
In what form did you give them credit in the month of October 2022?
Then credit, I took the bill, which they give me a bill every month, which is a statement. I take the statement. If you want to, I can show you what I'm doing.
I know what he's referring to. Can I show you?
Yeah.
The defendant tries to pretend. He never meant to enter a legal agreement, but he signed the contract, moved in immediately, and enjoyed every benefit it offered. And now he is facing the consequences. He wants to act like the rules were unclear, but the moment you take possession of a place, you show you understand the deal. And his new tactic is to pretend he was tricked, and everyone in the room can see right through that routine. And the judge knows it too, because the timeline speaks louder than any speech he's giving today, and he's trapped in his own contradictions. And the more he talks, the deeper he digs himself, because he keeps running from the basic truth that he accepted the terms from day one, and everything he's saying now is just noise and desperation, wrapped in confusing language, and none of it is working in his favor.
Well, show him, and then
I got copies for him. Here's what he's getting, Your Honor. We have a third-party billing company called Zigo. And so what they do is every month they bill the utilities. So he gets this bill, and then you'll see at the bottom what he writes is pay to the order of Peninsula Place. And so what he's taken, so for example, the top one says pay to the order of Peninsula Place, $662.12. That amount is his monthly rent plus the $123.12 in utilities that are at the top. There's 3 of these that I've attached. So what he does is he cuts off the bottom and he mails that in as with instructions to pay to the order of Peninsula Place, as if that's a check.
have this marked as plaintiff's exhibit and 2. The ledger being 1. But Mr. Lane, you have a copy of what I've marked as plaintiff's exhibit 2. Is what Mr. Fantera described, is that correct? Is that what you do?
Yes, I'm accepting the credits that's given to me, and I'm transferring to that.
Who's giving you this credit? They who?
So Peninsula Place, so in the beginning, when I signed up with Peninsula Place, I gave my principal information. So those payments are supposed to come to me as credit. So
what payments?
The payments that's coming every month. So those payments, they're trying to hold me liable for it, and I'm taking the credits that I'm receiving and dishing it back to Peninsula Place.
Who's giving you credit?
You said who's giving me credit?
Yeah.
I have credit, Your Honor. I have a security interest.
In what?
And this so-called contract with Peninsula Place.
Okay, but who's giving you credit? Young man, you keep using these terms, payment, credit, and it seems to me as I'm listening to you that you're using them improperly. So my question is, have you paid anything to the plaintiff in US dollars or anything that evidences US dollars
No, I haven't paid in US dollars. But
or anything evidencing US dollars, like a check, credit card, anything like that?
so this is,
No, that's a yes or no.
can you repeat the question, Your Honor?
Have you, let me just break it apart so we get it real clear. Have you paid for the months of October 2022, November 2022, December 2022, January 2023, or February of 2023? Have you paid to anything to Peninsular Place in US dollars?
No, Your Honor.
Have you paid anything to them that is evidence of an account which holds US dollars?
Yes, Your Honor.
What? And what account is it attached to? You better be careful about answering my question. Because if you're telling me that you gave them or paid them something that evidences an account that can access US dollars, show it to me.
Sometimes a defendant delivers a statement so confusing that the entire room freezes for a moment, trying to figure out what they just heard. And this was one of those moments where the words sounded like a scrambled puzzle with no picture on the box. And the judge looked up like he needed subtitles for a language nobody speaks. And the attorney couldn't hide the reaction because even they knew the statement made absolutely no sense. And the courtroom energy shifted from frustration to disbelief, and everyone watching felt lost for a second. And then the reality set in that the defendant thinks this chaotic approach is strategy. And the truth is the confusion doesn't hide anything. It only shows how unprepared he really is. And in that moment, the whole room realized this case was about to get even stranger, and not in a good way.
You said that's access to US dollars? Right here.
What is that? What Mr. Fantera just gave?
Yes,
How does that access US dollars?
because, Your Honor, this account, I'm the holder and I have the interest.
Then show me the balance on that account.
They show you the balance?
Yep.
Just showed you the balance.
No, you haven't shown me anything. Show me the balance on the account. If you give somebody something that evidences that they can access US dollars, then there is a balance on that account in terms of what you're giving them. Much as if somebody gave a check to them, they would be able to show the account for which they can then present that check and receive US dollars. Show me that account, Mr. Lane.
Like I said, Your Honor, I don't know what else you're asking for. This is the,
No, you know exactly what I'm asking for.
you're asking for something that's coming out.
Something that evidences that by that piece of paper that you've given them, that they can access US dollars.
Okay. I don't have any other account besides this, Your Honor.
You don't have any what?
I said I don't have any other evidence besides this right here.
That does not show me that they can access US dollars.
Okay.
Where would they take that to, in your mind? Where would they take that to access United States dollars?
Put it on the ledger.
Where would they take it to access US dollars?
So, okay. So, Your Honor, so I got a question. As far as landlord and tenant relations, relationships, it's sitting here.
I'll try to answer your question as soon as you answer mine.
Okay.
Where would they take it to access US dollars?
They would take it and take the check and put it on the ledger with my credit. Because if I owe something, Your Honor, it would be in the negative balance. How can I pay something that's in a positive balance? How can
You don't have a positive balance.
this is
You have given them a piece of paper that you yourself just said is a check. So where would they take that to access your account
so, Your Honor,
and receive US dollars?
they're acting in dishonor. They're taking it and they never said anything about or object to it. So it was off
Oh, they're objecting now, certainly. Where would they take it, Mr. Lang?
so where would they take it? I mean, as far as they have a security deposit deposition bond. So they have it in a financial institution.
What financial institution
I'm not,
would they take it to get cash from your check, as you call it, that would then be debited from your account? Where would they take it?
debited, so what about the credits, Your Honor?
I don't see a credit.
On this paper, it says credit, payments, and credits.
That's not what it means, to the extent it says that. You have no credit. Where would they take it to get US dollars?
So where would they take it? They would take it out of my trust, Your Honor.
Out of your trust.
Yes.
Where is this trust located?
We all have a trust in it.
Okay, let's say we all do. I'm not accepting your premise, but let's say we all do. Where is your trust located?
I'm not sure where it's located, Your Honor.
The judge asks the simplest question possible, a direct yes or no, and somehow even that turns into an adventure with this defendant who refuses to answer straight. And he circles around the question like he's avoiding a trap. But the judge isn't asking anything complicated, and the courtroom grows tense because the more he dodges, the more obvious the hesitation becomes, and it's clear he's trying to avoid admitting something that will lock him in place. And the judge is losing patience with each second, and everyone watching wonders why a basic confirmation is suddenly a challenge. And finally, the judge leans in, reminding him that this isn't a debate. It's procedure. And the defendant still tries to dance around it, hoping confusion will save him. And it absolutely will not. And the tension is building fast because this stall tactic is falling apart instantly.
So if they wanted US dollars for this thing you purport to be a check, you can't tell them where to take it.
In the Treasury.
Which treasury?
The Treasury.
Oh, so they have to go to the US Treasury with this thing that purports to be a check. Really?
They were pulling from the Treasury. That's why they asked for my information.
Who is pulling from the Treasury?
Peninsula Place, Your Honor.
So Peninsula Place is pulling from the US Treasury.
They got the account attached to my name with my social and my information.
So they're pulling from the US Treasury because of that?
Say that again?
So because of that, they're pulling from the US Treasury?
I mean, they're charging the account. So this account has my information tied into it, which is showing that it's already prepaid. So what they're trying to do is Peninsula is trying to make me repay.
You've never paid anything, so they're not trying to make you repay, they're trying to make you pay.
Your Honor, so how did we get here if I provided my information to Peninsula Place?
We got here because you have never provided them anything.
Okay.
To pay on this account in US dollars or anything evidencing US dollars. That's how we're here for 5 months. You haven't done that.
Okay. So in the contract, it says payment and then specify what type of payment.
The defendant starts arguing about consideration in the contract like he's discovered a secret legal loophole. But the judge and attorneys know this argument has nothing to stand on. And the truth is very clear. He got housing, meaning he received full benefit from day one. And that alone satisfies the entire contract exchange. And everyone watching can see he's trying to twist simple law into something. It isn't, and the courtroom grows heavy with disbelief as he rambles through explanations that lead nowhere, and it's obvious he's fishing for an escape route, and none exists because the fundamentals are not on his side, and with every sentence he proves he doesn't.
I'm asking you, have you paid them in US dollars?
No, payment credit.
But you have no credit.
Yeah, this is evident.
Hold on.
Okay.
In order to pay in credit, if you will, You must have something that evidences a balance on that credit. I've already asked you once. Why not? I'll ask you again. Show me something that evidences the credit.
That shows the credit, the birth certificate, and a social security number showing my line of credit that I applied.
So how much is in that line of credit?
You say how much is in the line of credit?
Sure. If you got a line of credit, it's got to have a value. So how much is in it?
I believe everybody has $1 billion.
The judge walks in with a serious tone, and this defendant still tries to argue that money isn't real, like he's living in an alternate universe where bills pay themselves and responsibilities disappear, and the courtroom can't help reacting because the argument is so bizarre that nobody knows where to even begin, and the judge keeps reminding him that reality does not change based on personal belief, and refusing to acknowledge currency doesn't remove debt. And the entire situation shows how deep this mindset runs because he's willing to argue anything except the truth. And the judge stays firm, not letting a single imaginative excuse distract from the facts, and the tension builds as the defendant realizes he's running out of fantasy defenses and the courtroom is moving forward whether he accepts reality or not. And that moment hits him harder than anything he's said so far.
I didn't ask everybody. I'm asking how much is in your line of credit?
Well, for what Peninsula Place, whatever.
No, I'm asking you. You're saying that your birth certificate and the Social Security, you have a line of credit. I don't believe that to be the case, but what the heck? Let's ask you, how much is then in your line of credit?
This is the part where the entire sovereign citizen strategy gets exposed, and not by someone trying to be nice, but by an attorney who sees the scam from the inside, and he's explaining exactly how these tactics trap people into false promises and unpaid debts. And the courtroom listens closely because every detail is shining a bright light on a scheme that many fall for, and the defendant sits there hearing his entire belief system dismantled piece by piece. And the attorney continues calmly breaking down each trick and every misleading step. And the judge takes it all in, knowing the truth is right there in front of him. And the audience realizes this is just a misunderstanding. This is a pattern. And the more the attorney talks, the clearer the entire picture becomes. And it's not flattering for anyone following that ideology.
Not sure, Your Honor.
So if you're not sure how much is in there, and you give them this thing that evidences, as you're saying, just take this 1 month of $662.12, you don't know if that can be subtracted from that credit you supposedly have.
I'm believing at least $1 billion worth of credit, Your Honor.
Oh, you have $1 billion worth of credit.
We all have credit, Your Honor.
Well, I'm not worried at this point about anybody else's credit. I'm worried about yours. You're saying you have $1 billion, but you have nothing that shows me that you have $1 billion worth of credit.
Mhm.
Mr. Lane, plaintiff is claiming that you owe them $3,320.17. Tell me every reason why I should not give them a judgment for that amount.
That's going against the Michigan Consumer Protection Act.
What particular provision are you claiming of the Michigan Consumer Protection Act?
Enter into a consumer transaction in which the consumer waives or purports to waive right, benefit, or immunity provided by law, unless a waiver is clearly stated and the consumer has specified consent to it. I never gave no consent.
The defendant begins quoting complicated phrases, acting like he discovered hidden laws and secret meanings buried in dictionaries and the courtroom is trying to follow. But the statements make less sense with every sentence, and the judge looks like he's waiting for something logical to finally appear, but nothing does. And the attorney quietly shakes his head because he's heard these lines so many times before. And they never work, and the courtroom atmosphere shifts to confusion, mixed with disbelief, and everyone can tell the defendant thinks he's dropping powerful legal points, and in reality, he's just stacking nonsense on top of nonsense. And the judge tries to parse through the wording, but it leads absolutely nowhere. And the entire scene becomes proof that complicated words don't make a weak argument. Strong.
What have they asked you to waive?
You said where they asked me to waive
Mm-hmm.
my rights.
To
As a
what?
consumer.
As a consumer of what?
You said a consumer of what?
Yeah.
Of this contract.
What rights did they ask you to waive?
My interest.
What interest?
I have an interest in this so-called contract.
Oh, you do. You also have certain obligations under that contract.
So I have obligations.
Oh, yeah.
Okay.
Like payment.
Okay. According to, like I say, landlord and tenant relationship, pay the landlord for all the rent arranged under this rental agreement. That's basically what I have the security deposit for.
No, your security deposit is not under Michigan law for that reason.
What is for, Your Honor? That's what it says, security deposit permissible uses.
I mean, there is no security deposit under this lease. They do not require a security deposit. It's zero.
Okay. Even worse.
Under which
You don't have a security deposit.
Your security deposit is zero. You did not pay a security deposit when you moved in. This client does not require.
you say move in. All this from where?
And even if you had one, the Security Deposit Act, you can't apply it.
Sorry.
So, what other reason do you have why you don't owe this money?
And what other reason?
Yeah, you told me Landlord-Tenant Relationship Act, which you haven't pointed to a particular provision. You talked about a security deposit of which you have none, so that can't be a reason. I don't know, and you haven't pointed to anything under the Landlord-Tenant Relationship Act that would even be applicable in this particular case regarding the monies that you owe. You cited the Michigan Consumer Protection Act. There's been no benefit that they've denied you, no interest that they've denied you. So that can't apply. Give me anything else as to why you don't owe this.
Anything else why I don't owe? I don't understand what else that you're looking for. Like I said,
I want you to tell me every reason why I should not say and give them a judgment for this, the $3,320.17 plus their cost.
so Your Honor, I'm sorry, can you repeat that again?
Which part?
You saying, so how is this not like a contract of adhesion that is more beneficial to Peninsula Place?
I don't know what that meant. Explain what you're trying to say to me.
So it's two parties, and I consider the weaker part. So they wrote this contract and all in the benefit for them. So where did I have any say so in this contract?
The defendant claims he has some hidden account with endless funds, and the courtroom reacts because this story pops up every time sovereignty myths are involved, and none of it is grounded in actual law. And the judge listens patiently while the explanation turns more fantastical with each sentence. And the attorney watches, knowing the belief comes from internet rumors, not reality. And the idea that there's a secret treasury account waiting to be unlocked has been debunked countless times, and yet he clings to it like a lifeline. And the courtroom energy shifts as the judge prepares to shut the claim down firmly, and the truth settles in that no secret account exists and no imaginary financial loophole is going to erase months of unpaid rent. And the fantasy collapses right there in the middle of the hearing.
Well, you had the big say-so of no. You didn't have to sign it.
So ain't that false and misleading? They was never know.
No, it's not false and misleading.
It's supposed
They
to be
didn't.
disclosure.
They didn't force you to sign it. You signed it.
So I'm signing. So is this a loan that I'm getting from Peninsula Place?
No, you are not getting a loan from Peninsula Place.
So,
You are renting an apartment.
correct.
In consideration for the use of that apartment, which belongs to Peninsula Place, you're to pay them rent. You haven't for the last 5 months. Actually, you didn't pay it before then because Sarah paid it, but you haven't paid rent for the last 5 months.
Yeah, all bills are prepaid.
No, they're not.
Okay.
Your bill is not prepaid.
Like I said, it's in the positive balance. If I owe anything, it will be in the negative.
I don't even know what that means because your positive versus negative is different than anybody else I've ever come across.
You said my positive is,
Yes, right now, you're in the negative of about $3,320.17.
Your Honor, when I log into my portal, it shows a positive balance. I can't owe something in a positive balance. It's just if I log into my app on my mobile device to look at my bank account, it's in a positive balance.
Your bank account.
Yes, this is a positive balance. If I owe anything, it will be.
So you have the money, so you have $3,320.17.
I'm giving an example.
What's giving an example?
If I owe anything, it'll be in the negative.
I don't know what that means. You
So-
don't have a credit on this account. You owe them $33.20.17.
If I don't have a credit, Your Honor, how do they make up an account number with all my information? I had to give them something.
Yeah, you gave them your information. The only thing you haven't done is give them money.
So in other words, you're telling me that I have to repay them, which is already paid.
You never paid it.
Okay.
No matter how many times you keep saying it, you never paid it.
Like I said, Your Honor,
You've never paid anything since October.
I have federal questions.
You have federal questions. Okay, well, you can take those up where they'll hear those. I don't know what federal questions you have because every state question that you attempted to try to raise falls flat on its face. There's no violation of the Michigan Consumer Protection Act. There's no violation of the Truth in Renting Act. You haven't paid anything. You won't show me an account where that even evidences that you have the money. You haven't paid it.
So this account right here doesn't show my name, Your Honor.
You don't have an account. If you're talking about a financial account, you don't have an account. You haven't shown me one. I've asked you for it. You haven't shown it to me.
Like I said, the account is right here, Your Honor.
That's not your account.
So who account is it? It has my name on it.
You keep calling it an account. It is not an account. You'll have a lot of things that will have your name on them. They aren't your account.
They're tied into with me, and I have an interest.
Okay. You can have an interest. You can have all of that. You have nothing where they could go and get cash. Nothing where they could go and get anything that would even remotely represent payment on this account. And you haven't done so for the last 5 months.
So, Your Honor, on this ledger, it say payments credit.
Look, I'm not going to sit up there and go back and forth with you on that. I asked you just plain out. Tell me every reason why you don't think you owe this money.
So, Your Honor, I'm a responsible party, and I gave my endorsements. They accepted, and I'm demanding payment. They never gave me payment. Like I said, I have my birth certificate, I have the social security number showing that I am the
Do you
home.
have a bank account?
My bank account? What does the bank account have to do with?
Because that's usually how people pay for their rent.
Your Honor, all I'm doing is enforcing my rights.
I'm not sure which rights you think you're enforcing because I haven't heard one yet. Is there any other reason you believe that you don't owe this $33.20.17 that you have not already stated to me?
Any other reason? No, I don't have any other reason besides, like I said, Your Honor, it's already prepaid. And they're trying to make me pay twice.
The moment the defendant starts rambling, the attorney jokes about crayons because that's how disconnected the argument feels from actual law. And the courtroom shifts into an awkward silence as the defendant struggles to find something meaningful to say. And the judge waits for anything that resembles a real answer, but nothing comes, and the attorney highlights how absurd the logic is by pointing out the gap between reality and imagination. In the courtroom, witnesses how quickly the argument falls apart under the slightest pressure, and it becomes clear that the defendant is leaning on ideas that cannot survive even simple questioning, and the silence grows heavier with every passing second, and everyone realizes there's no path forward for him with arguments like these, and the judge is already preparing his response.
Acting in dishonor, accepting and not returning, not saying anything of it. They're not accepting. So they've been taking it ever since I started, maybe March last year?
Ma'am, your name is
It's Jane.
Jane, full name?
Jane Hogan.
Ms. Hogan. And what is your position with Peninsula Place?
I'm the property general manager.
Okay. And you would be familiar with the books and ledger regarding this particular unit?
Yes.
You had an opportunity to review that prior to coming to court today.
Yes.
Is it true that $3,320.17 is the balance that's owed on this account?
Yes, sir.
Thank you. Sir, is there any other reason why you don't think you owe that money?
Oh, yeah. They
Because I'm about ready to rule.
roll thoughts. Supposed to get a jury trial.
No. I set this for trial sometime back in December, actually.
So you waiving it for a non-jury trial?
Sir, you gave no objection nor requested a jury trial. So
Yeah, I gave no objection. Okay.
when I set the date on December 23rd, there was no objection to it. And because you had not requested a jury trial at any given point. So I'm not even going to get into that. You waived that right. Any other reason why you don't think you owe the money that's been testified to, sir?
No, Your Honor.
All right. Mr. Pantera, you forego closing argument.
Yes, Your Honor.
All right. Sir, anything else you want to say to the court?
So I have federal questions to appeal for higher court.
Yeah. As soon as I enter my judgment, you'll be able to appeal all you want. If you can perfect it.
The attorney reacts with shock when the defendant claims he's sitting on huge amounts of money because the story makes no sense at all, and nobody in the courtroom believes that someone capable of paying luxury prices would be refusing basic rent. And the judge tries not to react, but even he looks confused by the claim, and the courtroom energy shifts into disbelief as everyone waits to see if there is anything to support the statement. And of course there is, and the attorney points out how ridiculous it sounds when someone claims wealth while avoiding even the smallest responsibility. And the judge looks ready to move past the nonsense because he's heard enough. And the courtroom can sense that the patience is running out quickly. And the truth is creeping in that the defendant is just hoping wild claims will distract from the facts, and it's not working.
So the court, having heard the testimony in this case, the court would find that plaintiff has sustained their burden of showing that the defendant owes $3,320.17 in outstanding rent and charges on this account. And the court would order a judgment to the plaintiff in that amount, plus its cost. That would constitute then the redemption amount on this premises. The defendant would have 10 days to pay that, which means he would have to pay that by February 24th, or a writ of restitution or order of eviction may issue. I will sign a judgment.
Should I show it to Mr. Loughlin?
Show it to him if you'd like, or you can present it to the court. I've issued my judgment.
Okay.
The court has signed that judgment. Thank you.
The attorney points out that every rental contract lists a dollar amount, and you either pay it or you don't. There's no mystery hidden between the lines, and the defendant tries to dodge responsibility by pretending the payment was something else entirely. But the contract is crystal clear, and everyone knows it, and the judge waits for the defendant to make sense of his own argument. But he can't, and the gap between his story and the actual agreement keeps growing. And the courtroom feels the tension rise as he keeps trying to dodge accountability, and the attorney calmly dismantles every attempt to twist the contract into something imaginary. And the truth is, there is no confusion. He simply didn't pay, and everything he's saying now is an attempt to rewrite history, and the judge sees it perfectly. The attorney explains one simple truth: you must pay before you can claim anything was paid twice. And this defendant hasn't paid even once in months, and the courtroom grows still because the facts land hard and undeniable. And the defendant tries to argue around them, but there's no escape from reality, and the judge listens without reacting. Because the truth stands on its own, and the attorney continues explaining how housing requires upkeep services and real costs, and these buildings don't magically appear free for whoever wants them, and the defendant rolls out more theories and excuses, but none of them answer the basic issue that he hasn't paid rent even once, and the judge prepares his ruling because the argument is over and the reality is set in stone, and the courtroom knows exactly what's coming next.